Here is a summary of the June 5th, 2025 Supreme Court opinion in the case called Smith and Wesson Brands, Inker versus Estados Unidos Mexicanos, case number 23-1141. Please note that this summary is read by an automated voice. The questions presented in this case are: 1. Whether the production and sale of firearms in the United States is the proximate cause of alleged injuries to the Mexican government stemming from violence committed by drug cartels in Mexico. 2. Whether the production and sale of firearms in the United States amounts to aiding and abetting illegal firearms trafficking because firearms companies allegedly know that some of their products are unlawfully trafficked. Justice Kagan delivered the opinion for a unanimous court. Justice Thomas and Justice Jackson each filed concurring opinions.
Justice Kagan's unanimous opinion, the Protection of Lawful Commerce in Arms Act, PLCAA, bars certain lawsuits against manufacturers and sellers of firearms. As relevant, it provides that a qualified civil liability action may not be brought in any federal or state court, 15 U.S.C. Section 7902A, and defines that term to include a civil action or proceeding against a firearms manufacturer or seller stemming from the criminal or unlawful misuse of a firearm by a third party, Section 79035A. But PLCAA's general baron these suits has an exception, usually called the predicate exception, relevant here. That exception applies to lawsuits in which the defendant manufacturer or seller knowingly violated a state or federal statute applicable to the sale or marketing of firearms, and the violation was a proximate cause of the harm for which relief is sought. The predicate violation PLCAA demands may come from aiding and abetting someone else's firearms offense. PLCAA itself lists as examples 2 ways in which aiding and abetting qualifies: when a gun manufacturer or seller aids and abets another person in making a false statement about a gun sale's legality or in making specified criminal sales, and more broadly, because federal law provides that whoever aids and abets a federal crime is punishable as a principal. 18 U.S.C. Section 2A, a gun manufacturer that aids and abets a federal gun crime may itself commit a PLCAA predicate violation. Here, the government of Mexico sued 7 American gun manufacturers, alleging that the companies aided and abetted unlawful gun sales that routed firearms to Mexican drug cartels. The basic theory of its suit is that the defendants failed to exercise reasonable care to prevent trafficking of their guns into Mexico, and so are responsible for the harms arising there from the weapon's misuse. That theory implicates PLCAA's general prohibition, so the complaint tries to plead its way into the predicate exception. It alleges that the manufacturers were willful accessories in unlawful gun sales by retail gun dealers, which in turn enabled Mexican criminals to acquire guns. And it sets out 3 kinds of allegations relating to how the manufacturers aided and abetted retailers' unlawful sales. The manufacturers allegedly, 1. Supply firearms to retail dealers whom they know illegally sell to Mexican gun traffickers. 2. Have failed to impose the kind of controls on their distribution networks that would prevent illegal sales to Mexican traffickers. And 3. Make design and marketing decisions intended to stimulate cartel members' demand for their products. The district court dismissed the complaint, but the First Circuit reversed, finding Mexico had plausibly alleged that defendants aided and abetted illegal firearms sales. Held, because Mexico's complaint does not plausibly allege that the defendant gun manufacturers aided and abetted gun dealers' unlawful sales of firearms to Mexican traffickers, PLCAA bars the lawsuit. A. Federal aiding and abetting law reflects the view that a person may be responsible for a crime he has not personally carried out if he deliberately helps another complete its commission. To aid and abet a crime, a person must take an affirmative act in furtherance of the offense and intend to facilitate its commission, or, as Judge Learned Hand stated these requisites, must participate in a crime as in something that he wishes to bring about, and seek by his action to make it succeed. United States versus Peony, 100 F 2nd floor 401-402. In elaborating on that demand, this court has developed several ancillary principles. First, aiding and abetting is most commonly liability for specific wrongful acts, though broader liability for a category of misconduct is possible if a wrongdoer's participation is correspondingly pervasive, systemic, and culpable. Second, aiding and abetting usually requires misfeasance rather than nonfeasance. Absent an independent duty to act, failures, omissions, or inactions will rarely support liability. And third, routine and general activity that happens on occasion to assist crime, in essence incidentally, is unlikely to count as aiding and abetting. Thus, for instance, an ordinary merchant does not become liable for criminal misuse of her goods simply by knowing that, in some fraction of cases, misuse will occur. Two of this court's cases illustrate these principles. In Direct Sales Co. v. United States, 319 U.S. 703, the court held that a mail-order pharmacy could be convicted for assisting a small-town doctor's illegal distribution of narcotics. The pharmacy sold the doctor massive quantities of morphine, 5,000 to 6,000 half-grain tablets monthly, versus the typical physician's 400 quarter-grain tablets annually, actively stimulated his purchases through special discounts and high-pressure sales methods, and continued these practices despite law enforcement warnings. All this showed that the pharmacy not only knew of and acquiesced in the doctor's illicit enterprise, but joined both mind and hand with him to make its accomplishment possible. By contrast, in Twitter, Inc. v. Tamne, the court dismissed aiding and abetting claims against social media companies for aiding and abetting a terrorist attack carried out by ISIS. Although the plaintiffs there alleged that ISIS supporters used the company's platforms for recruiting and fundraising, and that the companies knew this but failed to adequately remove ISIS content, that was not enough to make the companies liable for ISIS's terrorist acts. At most, the plaintiffs allege that the companies provided their platforms for general use, then stood back and watched as ISIS misused them, Idiadi at 499, and more was needed for a provider of generally available goods and services to be liable for a customer's misuse of them, for example, conduct of the kind in direct sales. B. Against the backdrop of that law, Mexico's complaint does not plausibly allege that the defendant manufacturers aided and abetted gun dealers' unlawful sales of firearms to Mexican traffickers. To begin, the complaint sets for itself a high bar. It does not pinpoint, as most aiding and abetting claims do, any specific criminal transactions that the defendants allegedly assisted. Instead, it levels a more general accusation that all the manufacturers assist some number of unidentified rogue dealers in violation of various legal bars. The systemic nature of that charge cannot help but heighten Mexico's burden. To survive, it must be backed by plausible allegations of pervasive, systemic, and culpable assistance. Mexico's lead claim that the manufacturers elect to sell guns to, among others, known rogue dealers fails to clear that bar. For one thing, it is far from clear that such behavior, without more, could ever count as aiding and abetting under the court's precedents. And in any event, Mexico has not said enough to make its allegations on this point plausible. It does not confront that the manufacturers do not directly supply any dealers, and its complaint does not name alleged bad apple dealers, or provide grounds for thinking that anyone up the supply chain often acquires that information. What Mexico has plausibly alleged is only that manufacturers know some unidentified dealers routinely violate the law, but this describes indifference rather than assistance, similar to the insufficient allegations in Twitter. For related reasons, Mexico's second set of allegations, that the manufacturers have declined to suitably regulate the dealers' practices, cannot fill the gap. Of course, Responsible manufacturers might well impose constraints on their distribution chains to reduce the possibility of unlawful conduct. But a failure to do so is what Twitter called passive nonfeasance. Such omissions and inactions, especially in an already highly regulated industry, are rarely the stuff of aiding and abetting liability, and nothing in Mexico's allegations makes them so. Finally, Mexico's allegations about design and marketing decisions add nothing of consequence. Mexico focuses on production of military-style assault weapons, but these products are widely legal and purchased by ordinary consumers. Manufacturers cannot be charged with assisting criminal acts simply because Mexican cartel members also prefer these guns. The same applies to firearms with Spanish language names or graphics alluding to Mexican history. While they may be coveted by the cartels, they also may appeal to millions of law-abiding Hispanic Americans. Even the failure to make guns with non-defaceable serial numbers cannot show that manufacturers have joined both mind and hand with lawbreakers in the manner required for aiding and abetting. C. This conclusion aligns with PLCAA's core purpose. Congress enacted PLCAA to halt lawsuits attempting to make gun manufacturers pay for harms resulting from the criminal or unlawful misuse of firearms. Mexico's suit closely resembles those lawsuits, and while the predicate exception allows some such suits to proceed, accepting Mexico's theory would swallow most of the rule. The court doubts Congress intended to draft such a capacious way out of PLCAA, and in fact, it did not. Reversed and remanded.
Justice Thomas's concurring opinion. The court today correctly decides that Mexico has not plausibly pleaded that its suit falls under the predicate exception to the Protection of Lawful Commerce in Arms Act, PLCAA. This exception allows otherwise prohibited suits against gun manufacturers to go forward if, among other requirements, the manufacturer has knowingly violated a state or federal statute applicable to the sale or marketing of the product. I write separately to note that the court's opinion does not resolve what a plaintiff must show to establish that the defendant committed a violation. It concludes only that Mexico has not adequately pleaded its theory of the case, that as a factual matter, the defendant gun manufacturers committed criminal aiding and abetting. In future cases, courts should more fully examine the meaning of violation under the PLCAA. It seems to me that the PLCAA at least arguably requires not only a plausible allegation that a defendant has committed a predicate violation, but also an earlier finding of guilt or liability in an adjudication regarding the violation. Allowing plaintiffs to proffer mere allegations of a predicate violation concurring would force many defendants in PLCAA litigation to litigate their criminal guilt in a civil proceeding without the full panoply of protections that we otherwise afford to criminal defendants. And these defendants might even include ones who were cleared in an earlier proceeding, such as through a non-charging decision or a not guilty or not liable verdict. Such collateral adjudication would be at best highly unusual and would likely raise serious constitutional questions that would counsel in favor of a narrower interpretation, particularly given the PLCAA's aim of protecting gun manufacturers from litigation. This issue warrants careful consideration.
Justice Jackson's concurring opinion. The court holds that Mexico's complaint fails to plausibly allege that gun manufacturers aided or abetted violations of firearms laws as necessary to trigger the predicate exception to the Protection of Lawful Commerce in Arms Act. I agree. I write separately to explain that, in my view, the complaint's core flaw is its failure to allege any non-conclusory statutory violations in the first place. Tellingly, that failure exposes Mexico's lawsuit as precisely what Congress passed PLCAA to prevent. PLCAA was Congress's response to a flood of civil lawsuits that sought to hold the firearms industry responsible for downstream lawbreaking by third parties. Activists had deployed litigation in an effort to compel firearms manufacturers and associated entities to adopt safety measures and practices that exceeded what state or federal statutes required. Congress expressed concern that these lawsuits attempted to use the judicial branch to circumvent the legislative branch. PLCAA embodies Congress's express rejection of such efforts, stymieing those who, as Congress put it, sought to accomplish through litigation that which they have been unable to achieve by legislation. Put differently, PLCAA reflects Congress's view that the democratic process, not litigation, should set the terms of gun control. Viewed in light of this objective, Congress's inclusion of the predicate exception makes perfect sense. The exception allows lawsuits to proceed, despite PLCAA's general grant of immunity, if the complaint alleges that a gun manufacturer or seller knowingly violated a state or federal statute applicable to the sale or marketing of the product, and the violation was a proximate cause of the harm for which relief is sought. Section 7903, open parenthesis, 5, close parenthesis, open parenthesis, A, close parenthesis, open parenthesis, 3, close parenthesis. By tying the exception to statutory violations, Congress kept the door open to civil liability, but only liability flowing from duties that the people, rather than the courts, had chosen to impose. PLCAA's predicate exception might well be triggered by aiding and abetting another's violation of a firearms statute, as the provision's two examples make clear. First, Section 7903, 5A, G, I describes, for example, aiding and abetting any person in making any false or fictitious oral or written statement with respect to any fact material to the lawfulness of the sale or other disposition of a qualified product, conduct that violates 18 U.S.C., Sections 922M, 923G, or 924A, 3A. Likewise, Section 7903, Subclause 5, Subclause A, Subclause 3, Subclause 2 covers aiding and abetting any other person to sell or otherwise dispose of a qualified product, knowing or having reasonable cause to believe that the actual buyer of the qualified product was prohibited from possessing or receiving a firearm or ammunition under 18 U.S.C. Sections 922G and N, sales that breach Sections 922BD or T1, for instance. Critically, both predicate exception examples relate to the aiding and abetting of particular statutory violations. All that Mexico alleges here is that firearms industry-wide practices, though lawful on their own, facilitated dealers' unspecified downstream violations. Mexico does not tether its claims to alleged statutory breaches, nor does it identify the dealers who would be the principals for any underlying statutory violations, as the court observes. At bottom, then, Mexico merely faults the industry writ large for engaging in practices that legislatures and voters have declined to prohibit. It is for these reasons that I view Mexico's allegations as insufficient to satisfy PLCAA's predicate exception, regardless of whether the business practices described might suffice to establish aiding and abetting or other forms of vicarious liability in distinct statutory or common law contexts. Devoid of non-conclusory allegations about particular statutory violations, Mexico's lawsuit seeks to turn the courts into common law regulators. But Congress passed PLCAA to preserve the primacy of the political branches, both state and federal, in deciding which duties to impose on the firearms industry. Construing PLCAA's predicate exception to authorize lawsuits like the one Mexico filed here would distort that basic design.
Case implications. The Supreme Court's unanimous decision in Smith and Wesson versus Estados Unidos Mexicanos firmly preserves the protection of lawful commerce in Arms Act's shield against civil liability for firearms manufacturers based on criminal misuse of their products by third parties. By narrowly interpreting what constitutes aiding and abetting under the predicate exception, the court establishes that manufacturers cannot be held liable merely for continuing to sell legal products to distributors who serve retailers they know may engage in illegal sales. This ruling creates a high threshold for establishing aiding and abetting liability, requiring plaintiffs to demonstrate that manufacturers participate in illegal sales as in something that they wish to bring about, and seek by their action to make succeed, beyond mere knowledge of potential misuse. For the firearms industry, this decision reinforces PLCAA's effectiveness as a barrier to litigation predicated on systemic theories of liability, allowing manufacturers to continue standard distribution practices without fear of tort liability based on how criminals ultimately use their products. Justice Thomas's concurrence raises significant questions about whether the predicate exception requires a prior finding of liability or guilt regarding the underlying statutory violation rather than merely plausible allegations at the pleading stage. This perspective could potentially narrow the predicate exception even further by requiring plaintiffs to show that a defendant manufacturer has been previously adjudicated as violating a firearm statute before PLCAA's immunity can be overcome. Similarly, Justice Jackson's concurrence emphasizes that Congress intended PLCAA to preserve its own primacy in regulating the firearms industry, preventing courts from becoming common law regulators through tort litigation. Her opinion reinforces that PLCAA's predicate exception is designed to allow suits only where manufacturers violate specific statutory duties imposed by legislatures, not general theories of liability disconnected from express statutory violations. Together, these concurrences may guide lower courts toward even more restrictive interpretations of PLCAA's exceptions, further limiting the circumstances under which firearms manufacturers could face civil liability for how their products are distributed and used.